Our discussion today will focus on Articles 210 and 212 of the Revised Penal Code as amended. I am referring to the crimes of direct bribery and corruption of public officials. The crime of bribery is commonly but mistakenly understood as the act of a person who bribes a public official. This notion is wrong. You know why? Because the act of a person who makes an offer of or who actually bribes the public officer constitutes the crime of corruption of public official under Article 212 of the Revised Penal Code, while the act of a public officer who accepts an offer of or who actually receives the bribe is what is called bribery under Articles 210, which is direct bribery, 211, which is indirect bribery, and 211-A, which is qualified bribery, all of the Revised Penal Code. Since in bribery there must be a giver and a receiver, it follows that when bribery is committed, the crime of corruption of public official is likewise committed. Otherwise stated, the giver of the bribe is punished for corruption of public official, while the receiver of the bribe, who must be a public officer, is punished for bribery. In other words, the bribe giver commits the crime of corruption of public official, while the bribe receiver commits the crime of bribery, either direct bribery, indirect bribery, or qualified bribery. Let's now go to the elements of direct bribery under Article 210. First element, that the offender is a public officer. Second element, that he accepts an offer or promise or receives a gift or present by himself or through another. Third element, that such offer or promise, gift or present has been given in consideration of the public officer's commission of a crime or any act not constituting a crime, or in consideration of the public officer's refraining from doing something which is his official duty to do. And the fourth element is that the act which the offender agrees to perform or which he executes be connected with the performance of his official duties. Let us discuss the first element of direct bribery, that the offender is a public officer. The term public officer refers to the public officer as defined in Article 203 of the Revised Penal Code. Hence, he must be, letter A, taking part in the performance of public functions or performing public duties in any branch of the government, whether in a permanent or temporary capacity and regardless of his rank or class. And letter B, such authority to take part in the performance of public duties must be by direct provision of law, appointment by competent authority, or by popular election. Let us go through some examples for your better understanding. Example number 1. X, a job order employee who works as a clerk in the office of the mayor, is a public officer. Here, even if X is merely a temporary employee, being a JO or job order employee, the temporary performance of public duties is enough to make X a public officer for purposes of direct bribery. Example number 2. A fiscal or a prosecutor, like me, is a public officer because he performs public duties, and he is authorized as such because he was appointed by competent authority. Prosecutors, for your information, are directly appointed by the President of the Philippines. Example number 3. A barangay captain is a public officer because he performs public duties as he was elected to do so by the people. Example number 4. A mayor of a local government unit is a public officer who performs public functions by virtue of popular election because he was elected by the people, and also by direct provision of law because the Local Government Code of 1991 enumerates or outlines the functions of a mayor. Take note that practically all public officials and employees whose offices are created by law can be said to be performing public functions by direct provision of law. Hence, for as long as a person is elected or appointed by competent authority, and regardless of whether his performance of public duties is merely temporary, he or she is to be considered as a public officer. Let's now go to the second element of direct bribery, that he accepts an offer or promise or receives a gift or present by himself or through another. Take note of the underscored portions of the slide. What is being offered or promised here must be a gift or present that is capable of pecuniary estimation, meaning capable of being valued in terms of money. Examples: money itself, a car, a house, a piece of land, jewelry, or services. Example number 1. Fiscal X has a son named Y who failed in one of the required subjects. It so happened that Z, Y's teacher, is a respondent in a rape complaint being handled by Fiscal X. The latter agreed to dismiss the complaint provided Z would give Y a passing mark. Z gave Y a passing mark. Is there direct bribery? The answer is no, because what was offered, meaning giving Y a passing mark, is not capable of pecuniary estimation. Now, what is the reason why the gift or present must be capable of pecuniary estimation? It is because of the penalty imposable for direct bribery, which is both imprisonment and payment of the fine. In the case of fine, the law says that it must not be less than 3 times the value of the gift. It will be impossible, therefore, to impose the fine if the gift or present cannot be valued in terms of money. Going back to the example, how can the giving of a passing mark be valued in terms of money? It cannot be, right? So, in that example which I cited, there is no bribery because the consideration is not capable of pecuniary estimation. The next point that I would like to emphasize under the second element is that the gift or present need not be actually received by the public officer with respect to the first and third forms of direct bribery. Now, when we get to discuss the third element, I will be discussing to you the 3 forms of direct bribery. But for now, limit your understanding to the principle that With respect to the first and third forms of direct bribery, hindi kailangang ma-receive talaga ng public officer yung gift or present, because the mere acceptance of an offer or promise of a gift or present is enough to constitute direct bribery of the first and third forms. Let us go through some examples. Example number 1. Policeman X accepted Y's offer of 100,000 pesos upon the understanding that X would arrest Z unlawfully. Here, the act that X agreed to do would constitute the crime of unlawful arrest under Article 269 of the Revised Penal Code. This is an example of the first form of direct bribery. Example number 2. X, a sanitary inspector from the LGU of Manila, for example, had an agreement with the owner of the building that he will not report sanitary violations in exchange for an offer of 50,000 pesos. This is an example of the third form of direct bribery. Here, the acceptance of the offer was to make X refrain from doing something which is his official duty to do. Also take note that the public officer himself receives the gift or accepts the offer. Or it could be that another person may receive the gift for him or may accept the offer for him. There must be proof, however, that this so-called other person acted in conspiracy with or on behalf of the public officer. Otherwise, only this other person will be held liable. Example number 1. X, pretending to act on behalf of Fiscal Y, received money from Z so that Fiscal Y would dismiss the criminal complaint against Z. In truth, however, X acted on his own without the knowledge of Fiscal Y. Question: is Fiscal Y liable for direct bribery? The answer is no. X alone is criminally liable, not for direct bribery, but for the crime of estafa under Article 3152C of the Revised Penal Code. This is called estafa by pretending to have given bribe. Example number 2. Fiscal X connived with Y, a private person, whereby the latter received the bribe money given by Z. There is no question here that Fiscal X is liable for direct bribery. But what about the private person Y? Will he also be liable for direct bribery, considering there was conspiracy between him and Fiscal X? What do you think is the answer? The answer is no. In the case of Go versus Sandigan Bayan, the Supreme Court stated that only the public officer may be charged under and be held liable for direct bribery under Article 210, while the person who conspired with the public officer or who made the promise, offer, or gave the gifts or presents may be indicted only under Article 212 of the Revised Penal Code for the crime of corruption of public officials, regardless of any allegation of conspiracy. So take note of that decision of the Supreme Court. Another point is that in direct bribery, it doesn't matter who initiates the crime. The private person may voluntarily offer or deliver the gift to the public officer, or the public officer himself or his intermediary may demand such gift from the private person. Example number 1. X, wanting to be sure that his complaint for estafa against Y would be acted upon favorably by Fiscal Z, met the latter at a restaurant and personally gave 100,000 pesos to Fiscal Z. Example number 2. Fiscal X demanded and received 100,000 pesos from Y as a condition for his dismissal of the complaint for estafa against Y. So, that shows you that it doesn't matter who initiates the crime, whether it be the bribe giver or the bribe receiver, the crime is deemed committed. In both examples, the public officer is liable for direct bribery, while the private person is liable for the crime of corruption of public official under Article 212 of the Revised Penal Code. The offer or promise of a gift must be accepted by the public officer, or the gift itself must be received by the public officer. Because if the public officer refuses to accept the offer or promise, or refuses to receive the gift, then he will not be liable for direct bribery. Only the private person who made the offer or delivered the gift is liable for attempted corruption of public official. Question: what if it is the public officer himself who demanded or solicited the gift, but the private person refused to accede to the demand? Will the public officer be liable for attempted bribery? The answer is yes. Here, the public officer commenced the commission of bribery but was not able to perform all the acts of execution which should produce the felony by reason of some cause or accident other than the public officer's spontaneous desistance. That is, that the private person refused to give in to the public officer's demand. For example, the judge demanded 500,000 pesos from a litigant in exchange for a favorable decision. The litigant refused and instead sought the help of the police to entrap the said judge. Another important question: is there direct bribery in the frustrated stage? The answer is no. Direct bribery can be committed only in the attempted and consummated stages. There is no frustrated stage. Let me give you the reasons why. When the public officer demands a gift, but the person demanded refuses to give in to the demand, the crime is merely attempted. Diba? In the attempted stage of a felony, there is an attempt when the offender commences the commission of a felony by overt acts, but he does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. What is that cause or accident? The refusal of the person to give in to the demand of the public officer. That's why it is merely in the attempted stage. And that is the reason why he is not able to perform all the acts of execution which should produce the crime of direct bribery. It is merely in the attempted stage. Now, the moment the public officer agrees with the offeror or giver, either letter A, to perform an act constituting a crime in connection with the performance of his official duty, or to refrain from doing something which it is his official duty to do, the crime is always consummated. The mere agreement in such a case consummates the crime. Here, there is never an instance that the felony is not produced. Diba? In our understanding of a felony in the frustrated stage is that the offender has performed all the acts of execution which should produce the felony as a consequence, but he does not produce it, or the felony is not produced by reason of causes independent of his will. But here, especially of the first and third forms of direct bribery, the mere agreement will already consummate the crime. The third element of direct bribery refers to the three forms or ways by which direct bribery can be committed. Let us discuss each of these forms. First form happens when the public officer agrees to perform or performs an act constituting a crime in consideration of any offer, promise, gift, or present. Now, if the act to be performed by the public officer amounts to a crime, as I have already emphasized in the previous slides, actual receipt of the gift is not necessary. Once there is a meeting of minds, even if the public officer has yet to perform the act amounting to a crime, the crimes of direct bribery and corruption of public official have already been committed. This is an example of a conspiracy as a crime in itself. Example of the first form of direct bribery. X, a litigant, and Y, a court stenographer, in consideration of 100,000 pesos, which X promised to give, agreed that Y would falsify her stenographic notes in order to make the testimony favorable to X. Here, the mere agreement between X and Y consummates the crime for both direct bribery and corruption of public official. In the above example, if the stenographer, pursuant to their agreement, actually falsifies her notes, then they will be criminally liable also for the other crime of falsification. For the court stenographer, she will be liable for direct bribery and for the crime of falsification of a public document. And for the litigant X, he will be liable for the crime of corruption of public official and also for the crime of falsification of a public document, because here he is a principal by inducement. The second form of direct bribery happens when a public officer receives and accepts a gift in consideration of the execution of an act which does not constitute a crime. Now, while it is true that the act to be performed by the public officer need not amount to a crime, the same must be unjust. Example number 1. Fiscal X found probable cause to charge Y for murder. In exchange for 500,000 pesos which Fiscal X received a week ago, the latter instead filed a case for homicide only. Question: is Fiscal X liable for direct bribery of the second form? The answer is yes. The act which Fiscal X performed, although it did not constitute a crime, is nevertheless unjust. Why? Because for the money he received, he instead filed a case for homicide, which has a lesser penalty than for a case for murder, which has an imposable penalty of reclusion perpetua. And that is unjust because it is unjust for the victim. Example number 2. Fiscal X found probable cause to charge Y for murder. On the promise of Y that he would deliver 500,000 pesos to Fiscal X, the latter instead filed a case for homicide only. Is Fiscal X liable for direct bribery of the second form? The answer is no, since the consideration is the execution of an act which does not constitute a crime. A mere promise to give a gift is not sufficient. The gift must be actually received and accepted by the public officer. Example number 3. Fiscal X agreed to dismiss the complaint for rape filed against Y in exchange for 500,000 pesos. Y delivered the money, which was readily accepted by Fiscal X. The latter, however, has yet to act on his promise to dismiss the said complaint. Is there direct bribery of the second form? Meaning to say, at this point in time, mako-consider na ba natin na meron ng direct bribery of the second form? The answer is no. A mere agreement on the part of the public officer to execute an act which does not constitute a crime is not sufficient. This second form of direct bribery requires that there must at least be an overt act on the part of such officer in pursuance of the agreement. This is so even if the public officer has received and accepted the gift. Take note that in this example, the public officer, although he will not be liable for direct bribery of the second form, he will instead be held liable for indirect bribery under Article 211 for accepting the gift by reason of his office. Pwede siyang ilagay dyan, pwede siyang ma-file ng kaso under indirect bribery. The third form of direct bribery happens when the public officer agrees to refrain or refrains from doing something which it is his official duty to do in consideration of a gift or promise. Here, the mere agreement by the public officer to refrain from doing something which it is his official duty to do in consideration of an offer or promise of a gift which is accepted by the public officer is enough to constitute direct bribery of the third form. Meaning to say, hindi kailangan talaga ma-receive ng public officer yung gift or present. The mere acceptance of the offer or promise of a gift is enough to constitute direct bribery of the third form. Example, X, a sanitary inspector from the LGU of Manila, had an agreement with the owner of an unsanitary building that he will not report violations of the LGU's sanitary ordinance in exchange for an offer of 50,000 pesos, is liable for direct bribery of the third form. If the act of refraining from doing something which is the official duty of the public officer, constitutes a crime in itself, take note, then the offender should be charged under direct bribery of the first form, not under the third form. For example, X, a chief of police, refrained from filing a case against a wedding collector who was caught in possession of gambling paraphernalia in exchange for 50,000 pesos. Here, he is liable for two crimes, for direct bribery of the first form and for the crime of dereliction of duty in the prosecution of offenses under Article 208 of the Revised Penal Code. Let's now go to the fourth element of direct bribery, which is that the act which the public officer agrees to perform or which he executes be connected with the performance of his official duties. Example number 1. X, a police officer, received 500,000 pesos from Y so that the latter's case, pending resolution at the fiscal's office, will be dismissed. Question, is X, the policeman, liable for direct bribery? The answer is no, because the act which X agreed to perform is not connected with the performance of his official duties. He is only tasked with law enforcement. He is only tasked with filing a case before the fiscal's office. It's not part of his duties to resolve a complaint, because the task of resolving a criminal complaint rests with the prosecutor or fiscal. Example number 2. If in the above example, X pretended to act on behalf of the fiscal and acted on his own without the knowledge of the said fiscal, then X will be liable not for direct bribery but for estafa under Article 3152C of the Revised Penal Code. I am referring to the crime of estafa by pretending to have given bribe. We shall now discuss the crime of corruption of public officials. These are the elements of corruption of public officials under Article 212 of the Revised Penal Code. First element, the offender makes offers or promises or gives gifts or presents to a public officer. Second element, the offers or promises are made or the gifts or presents given to a public officer under circumstances that will make such officer liable for direct bribery, indirect bribery, and qualified bribery. Here, the offender is the giver of the gift or the person who made the offer. I already emphasized this at the beginning of our discussion. Now, if the public officer does not accept the gift or does not accept the offer or promise of a gift, then there is only attempted corruption of public officer. The public officer, of course, will not be liable for direct bribery. Take note that the person who made the offer or the person who gave the gift is liable even if it was the public officer himself who solicited or demanded the gift or present.